I've seen blight designations applied all over the country in a number of different states, but Missouri in particular is one of the worst states in terms of how it uses blight designations in order to condemn properties and take them from one private owner and hand them over to another private owner. One thing that I want to stress is that under the state statutes, the definition of blight, there are several different state statutes that deal with blight. And so one of the things that is sometimes said is that, well, if we're declaring a blight designation for the purpose of one of these statutes, then it's not necessarily going to be effective for one of these other statutes. Unfortunately, the language that allows property to be declared blighted is virtually identical under every one of these state statutes. And so while city officials may intend to only use the blight designation for a specific purpose, nothing would bind a future city council or future representatives on that city council from deciding, we have this blight designation in place, why don't we go ahead and use it for one of these other purposes? So that's something important to keep in mind. Even if the people on the council at this time might be trusted to not use a blight designation for purposes of condemnation, a future city council might be able to use the blight designation for precisely those purposes. One thing that I would like the folks in this room also to understand is the extraordinary degree of deference that cities get when they decide to declare an area blighted. I don't want to get too technical, as far as using legal jargon, but when we talk about deference, courts usually want to allow legislatures to do their thing. They trust legislatures to make the right decisions for the right reasons. And so when a body like a city council has come to a position, especially on something like a blight designation, the courts very, very rarely second guess that decision.